August 21, 1999. Congress's own deadline for a health privacy law arrives and passes. Nothing. Under the trap Congress set for itself 3 years earlier, the job now belongs to the Department of Health and Human Services. What the department writes next becomes the privacy rule America still lives under, proposed to a storm of public comments, caught in a presidential transition and rewritten once before it ever bit. This is the story of the privacy rule. Health tech frontier. If you saw the last episode, you watched Congress build an escalator into HIPAA, 12 months for recommendations, 36 months to pass a privacy law, and if it failed, the department writes the rules itself by month 42. Congress failed. So in the final months of the Clinton administration, Health and Human Services picked up the pen with a mandate no agency had ever carried: the first national standards for health privacy. On November 3, 1999, HHS published its proposed privacy rule, and America wrote back. Nearly 52,000 public comments poured in: doctors, hospitals, insurers, patients, privacy advocates. The department made substantial changes in response. Whatever this rule would be, it would not be written in a vacuum. December 28, 2000. The privacy rule is published, the first national framework for health privacy in American history. It covers health plans, healthcare clearinghouses, and providers who bill electronically. And here's the part most people miss. It protects your health information in every form it takes: electronic, paper, even spoken words. 3 stated purposes: protect consumers' rights, restore trust in the system, and build a national privacy floor. Then Washington changed hands. The rule had been printed with a February 2001 effective date, one that slipped to April as the transition played out. And in March 2001, the new administration reopened the rule for another round of public comment. The health industry held its breath. The decision? The privacy rule takes effect April 14, 2001, as scheduled. The rule survived, but the department also promised changes. And that promise is the next turn in this story. Here's what the privacy rule actually handed you: the right to a notice of privacy practices. In plain language, the right to see and copy your own medical records, the right to request corrections, the right to an accounting of who your information was disclosed to, the right to request restrictions on how it's used. Before this rule, none of that was guaranteed nationally. After it, every covered provider in America owed you answers. One provision quickly proved unworkable, requiring signed consent before routine treatment, payment, and operations. Providers couldn't even use your information before your first face-to-face visit. Routine care delayed. So in March 2002, the department proposed modifications, and that August it finalized them. Consent for routine care became optional. In its place, a notice of privacy practices with a good faith effort to get your written acknowledgement. The stated goal: keep the protections strong while removing the rule's unintended barriers to care. April 14, 2003, Compliance Day. From this date, most covered entities, hospitals, practices, health plans, had to live the rule. Privacy notices at the front desk, minimum necessary limits on who sees what, patient rights honored on request. Small health plans got 1 more year, 7 years after HIPAA was signed with barely a word about privacy. Medical privacy was finally enforceable nationwide. The privacy rule set a national floor, and states could still build higher. Stricter state laws survive. But the rule was born in a paper world, and medicine was racing onto computers. Paper folders don't get hacked. Databases do. Electronic records would need defenses of their own. And in 2003, the security rule answered. That's the next full story. Subscribe so you don't miss it. This has been Health Tech Frontier. Subscribe for the next chapter.